Good day, aficionados. It is Saturday, March 19th, 2022. Well, it is Saturday, and what does that mean? That means it's time for the CrimeTalk weekly recap with all of the top stories throughout the week in one convenient location. Hope you enjoy it. Have a wonderful weekend. We'll see you next time on CrimeTalk.
Lori Vallow, Chad Daybell, yet another continuance. I have never seen a case where a motions deadline has not been set and a motions date to hear all the motions has not been set. I've never seen such piecemeal motions practice anywhere. Well, it gets better. As you may recall, the change of venue was granted in the Lori Vallow, Chad Daybell case. Basically, the court determined that they were not going to be able to get a fair trial in Madison and Fremont counties. It just wasn't going to be possible. And then the prosecutor said, hey, it's going to be really expensive for us to move the trial to the other side of the state, and there's going to be great costs associated with the prosecution, witnesses, family, as well as sheriff personnel having to keep those individuals obviously housed and to get them to court. It was going to be a huge expense. That's the only thing that matters at the end of the day when it comes kind of to the prosecution. Justice is expensive. I get it. But then they always say it's so expensive and they don't have to pay for it when, justice requires it. So I think the judge made the right decision moving the case over to Ada County, which is on the western side there of Idaho. And the prosecution then filed a motion to reconsider saying, hey, judge, look at the numbers that we have put together and it's going to be astronomical. It's going to cost hundreds of thousands of dollars to hold this trial. So please reconsider. And the proposed solution for the prosecution was, hey, let's pick a jury up there in Ada County. And instead of relocating everybody down in Fremont and Madison counties up to Ada County, we'll just bring the jury down. We'll put them in a hotel. They'll be focused, and we won't have all the expense and inconvenience of moving us, just inconvenience the jury. And they came up with all of these lists and this spreadsheet and said it's going to cost hundreds of thousands of dollars. Well, the prosecution has filed a motion captioned, Motion for Continuance of the State's Motion to Reconsider Transport or Transfer of Venue to Ada County. Now, what is the basis for that? Well, apparently the state puts in their motion that the state learned that personnel from the Ada County court system and representatives from the 7th Judicial District had a meeting on March 1st regarding the venue and trials in the Daybell cases. Further, the state learned some of the information discussed during those meetings may differ from information previously supplied to the state's witnesses. The state is attempting to ascertain the extent to which the information from March 1st, 2022 Ada County meeting differs from the information previously obtained by the state. The state discloses to the defense counsel was based on the original information obtained by the state's witnesses. Should this information stemming from the March 1st meeting differ, they will notify everybody. But therefore, out of abundance of caution, the state respectfully requests that the hearing on the state's motion to reconsider transport of jurors be continued to a date to both parties to allow the state time to learn and disclose to the defendants any additional or conflicting information. Well, that motion basically says, how do you say we got it wrong without saying we got it wrong? Well, that's how you do it. That's lawyer speak for that. Well, we're not sure. The information's changing. We're going to need a little more time. Okay, now it could come in lower or it could come in higher. My guess is it's probably going to be a little less expensive given the information provided in this motion, but we'll never know because we weren't at that March 1st meeting and the state is not saying exactly what was the difference just yet. But needless to say, another continuance requested, and I'm sure another continuance granted. The Lori Vallow, Chad Daybell cases is a case where literally nothing ever gets done. Let's go, Idaho. Let's speed it up. Chandler Halderson. Remember that guy? That's right. He was convicted of murdering and then dismembering his parents. Well, he doesn't want to go to his sentencing, which is coming up this Thursday. Now, Halderson is set to face his sentencing for killing his father, Bart, 50, and his mom, Krista, who was 53. Now, Halderson killed his parents after his father confirmed that he was not attending college, according to prosecutors, and he then chopped up his parents' bodies and hid them throughout Wisconsin. He hid his father's torso at his girlfriend's family property. From the torso, authorities were able to determine that Halderson shot his father in the back, but investigators have not been able to find parts of his mother's leg and cannot determine how he killed her. Sounds like a loving son, doesn't he? Well, the Dane County Deputy District Attorney, a guy by the name of William Brown, basically said in writings to the judge, the defendant has no right to simply skip a court hearing that might be uncomfortable or to avoid finally being held responsible for his behavior. Now, this defense, the pleadings by the prosecutor follows a motion filed by the defense attorney, Kathleen Dorrell, and she stated that Halderson signed an affidavit asking to skip the sentencing. Mr. Halderson consents to being absent from the sentencing hearing in this case, according to his attorney, and he waives any right to be present and not only requests, but requests to be absent. The attorney also argued that defendant's rights are not limitless, and in this case, Mr. Halderson does not have a legitimate reason to skip court. Today, Judge Hyland has not yet ruled on the motion from Halderson's defense team. The judge says he will make a decision sometime this week before the sentencing hearing, which is scheduled for Thursday, March 17th at 1:30 p.m. Now, since he was convicted of first-degree intentional homicide, Halderson faces a mandatory life sentence, but could still be granted the possibility of parole. Okay, let's take a look at this a little closer. Now, Mr. Halderson, not a good guy. I mean, he was kind of a liar, lied about just about everything, killed both of his parents, chopped them up, strategically placing them throughout the state and various parts of residence. But that's not the point. The point is he's been found guilty by his peers, and that jury found unanimously that he was guilty of killing both his parents. Well, part of the process is sentencing, okay? That is a critical stage of the proceedings. Most courts will not let the defendant skip a critical stage of the proceedings unless they are somehow being disruptive. Could you imagine if every defendant didn't want to hear what was going on at trial, so they just didn't show up? Yeah, no, not going to happen. Now, I'm not the judge in this case, and just like anyone has a right to do something, they can waive that right by knowingly, voluntarily giving up that right. Then they knowingly, voluntarily give up their right for their statement of allocution. They always get the last word. But at sentencing, you also have the victims that get an opportunity to speak about how this has impacted their life in regards to his parents that have been killed at his hands. That's usually pretty powerful, and it's usually pretty good for the defendant to have to hear it. So what would I do if I was the judge? If I was the judge, I'd say, oh no, young man, you are showing up at your sentencing hearing. And I would then issue a drag order, which means that if Mr. Halderson, does not come voluntarily to court, that you have orders from the court to drag him to court and prop him up in that little chair. The man is looking at life without parole, but guess what? As soon as he gets to prison and realizes this isn't very much fun, what is he going to do? He's going to claim that he received ineffective assistance of counsel, and the court should have let him be at the sentencing hearing because no court would ever allow him to do that. The guy's playing games, okay? Now, Mr. Halderson, here's my advice if you were my client. Hey, it sucks that we lost, but let's face it, it was a difficult case. We did what we could. We made the government crawl over glass to get a conviction, but guess what? I'm going to advise you not to say anything at sentencing because there will be an appeal. But this is what I want you to say. When the judge asks if you have anything you want to say at the moment of your statement of allocution, you say, bring it on. That's the way it should be done. It's just the way it is. That's what I would tell him to do. Come on. Don't be a little wimp. I mean, you managed to kill two people and chop them up. you can certainly take a couple of hours at court for a sentencing hearing. Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked.
How about some Lori Vallow and Chad Daybell? I'm starting to think that Judge Boyce is maybe watching CrimeTalk. Just last night, I was saying that I hope the judge denies any motions to continue because, well, frankly, this case is getting a little long in the tooth and needs to move along. Well, guess what? Judge Boyce actually did that. He denied the government's motion to continue the motions hearing set in regards to the motion to sever, as well as the motion to reconsider the transfer of the venue from Ada County back to Fremont County. So those are set for this Friday at 9:30 a.m. on the motion to sever, and then at 11 a.m. the change of venue hearing. And it's great. The judge states in his order that this case has gone on. These motions have been pending for some time. We're going to have a hearing because, frankly, I don't have any other time on my docket to reschedule this stuff, which is why I was getting a little concerned. If they keep continuing this stuff, it's just another reason to continue the trial, and everything should be moving forward. So good on Judge Boyce. Jussie Smollett, he wanted to go home. He got his wish. So Mr. Smollett was released last night, just 6 days into his 150-day sentence for felony disorderly conduct. Now, Mr. Smollett, as you may recall, was convicted of 5 counts of felony disorderly conduct in December after a jury found he did, in fact, lie to the police back in January 2019 and repeatedly since then by claiming that he was attacked by 2 white homophobic Trump supporters back in 2019. Well, last week, after an hour-long sentencing hearing where his attorneys begged the courts not to send Mr. Smollett to jail, Mr. Smollett was sent to the Cook County Jail for 150 days. Now, Mr. Smollett protested the sentencing, screaming that he was not suicidal, and if anything happened to him, he was obviously knocked off by somebody. Well, since then, Jussie Smollett's family and his legal team have taken to social media to explain why they think Jussie should be able to go home. The family claimed that he was immunocompromised and a high risk of COVID. They claimed that he was being restrained to a bed in the psych ward, and they claimed they were getting threats from people saying they were going to hurt the actor, despite Jussie being on 24-hour watch. Well, Mr. Smollett was released by an appellate court panel so he could contest his conviction. He was freed after he posted the request of a $150,000 personal recognizance bond. Okay, let's just say this is very rare. Normally when somebody goes to trial, they lose, they can appeal. Rarely. I mean, probably maybe 1% of the people get to remain at liberty, and they usually have to post a significant cash or surety bond. Never have I seen in 27 years an appellate bond that was a personal recognizance bond. I'm starting to think that a little bit of Jussie Smollett privilege is coming through here. As you may recall, Mr. Smollett had some pretty powerful friends that basically made this case disappear early on. It seems like maybe that Jussie Smollett privilege may be coming back. Anyway, appellate justices Thomas Hoffman and Joy Cunningham were the two judges who approved of Smollett's release, saying the defendant has been convicted of non-violent offenses and that this court will be unable to dispose of the instant appeal before the defendant would have served his entire sentence of incarceration. It is thereby ordered that the motion by the defendant, Jussie Smollett, to stay, which means to stop his sentence of incarceration, and to grant him a bond pending the disposition of the appeal or until further order of this court is granted. A third judge, Maureen Connors, disagreed, writing, "I dissent," and would deny the motion. Mr. Smollett's attorneys said that he had been refusing food during his stint in jail, ice water that had been his food and only liquid. His attorney stated, "I can only imagine if I was in jail for something I didn't do, I wouldn't be eating either." So apparently Mr. Smollett was engaging in a hunger strike. Well, either way, the attorneys claim that the trial and the judge have politicized everything related to Mr. Smollett, and they need to look out for their client and obviously the public interest. They stated there's no room for politics in the court system, and our appellate courts do not play politics. The attorneys also criticized Chicago for apparently trying Mr. Smollett twice for his crime, saying that his client had already paid the $10,000 and did the community service before the trial. And basically, the appellate courts are hopefully going to get it correct this time around for Mr. Smollett. We'll see. It's Chicago. I'm sure Mr. Smollett is going to walk on this completely, but we'll just have to wait and see. I guess I'm just getting more cynical as the older I get. There was a hearing held today in regards to Chad Daybell's motion for severance. Severance from what, Scott? Severance from having the same trial with Lori Vallow. Well, that's kind of a factual and legal impossibility at this point. Well, why is that? Well, because Lori Vallow is still at the state hospital being restored to competency. And it was somewhat alluded to today at the hearing that it doesn't appear as though there's been any change as it relates to Lori Vallow, with one exception that I'll get to in just a minute. Okay, so Mr. Pryor, Chad Daybell's attorney, has filed a motion some 5 months ago, and the court said, no, we're going to have a hearing today. Even though the prosecution wanted to delay the hearing, the court said, no, we're going to go forward because these matters need to be resolved for everybody involved. And the motion is severance. As you may recall, in the indictment, Lori Vallow, Chad Daybell are charged with conspiracy regarding the deaths of J.J. Tiley as well as Tammy, who was Chad Daybell's wife before she passed away and married Lori Vallow several days after her death. Nothing weird about that, for sure, right? Well, anyway, so normally when there is an indictment and there are co-conspirators, the trial goes together. They all go to trial together. The court has blocked out some 10 weeks for this trial, and the trial is not scheduled to commence until January of 2023. But really, I know it seems like a long time, but from the attorney's perspective, that's just right around the corner because there's a lot of work that needs to be done. So Mr. Pryor is trying to find out as much information as he can as to what is the evidence that is going to be presented against his client, like any attorney would do. Mr. Pryor is saying we need a decision because Chad Daybell is in custody and we cannot wait indefinitely for Lori Vallow to be restored to competency if and when she ever would be. And that makes complete sense. The prosecution says, well, he signed a waiver of speedy trial, so, there's not a big issue. Now, normally in state courts, when you sign a waiver of speedy trial, it usually means a 6-month period begins from a particular date. From the date that you sign it, that's the new 6-month period begins. Now, Chad Daybell signed a waiver of speedy trial. I took it to mean that it was from 6 months from that date, but they agreed to set the trial date out into January of 2023 because it is a death penalty case and it does require a lot more work. But it doesn't mean that you indefinitely waive your right to a speedy trial. You know, that pesky little thing in the Constitution that says you have a right to a speedy trial, a public trial, because, we didn't like it when the king said we're going to throw you in jail and we'll get around to a trial when we think it's okay or when it's convenient for us. And that was really the argument of the prosecution today. The prosecutor kept saying, and I don't know how many times she said it, but she said it a lot, which was judicial economy. What does that word really mean? Judicial economy means, Judge, it's going to be really expensive and inconvenient for us to do this case multiple times. Please don't make us do this case more than once. That's basically the government's argument. Judge, just doesn't make sense. Why we should have to do this twice, because it's the same evidence and it's just not fair to us. And it's going to be really expensive. Did we mention that, Judge? Really expensive. And it's going to take up a lot of time in your docket too. That is judicial economy. It's certainly a factor that the court has to consider when ruling on a motion for severance, but there's two more important issues here. Judicial economy is certainly a factor that the court must consider in making their decision, but there are other factors that the court also needs to consider. First, are there any Bruton issues? This came up during the hearing, and you can watch the hearing at the link below. So one of the things the court has to consider is whether there is a Bruton issue. And this is a case from the United States Supreme Court that goes back to 1968. And in that case, and let's make sure we get it all correct here, it was a joint trial between co-defendants. And one of the co-defendants was convicted of both armed postal robbery. Now, one of the defendants did not take the stand, but a postal inspector testified that the one defendant confessed orally and that the Mr. Bruton and the petitioner committed the robbery. The trial judge instructed the jury that although Evans' confession was competent evidence against him, it was inadmissible hearsay against Mr. Bruton and had to be disregarded in determining petitioner's guilt or innocence. Well, needless to say, the co-defendant and Mr. Bruton both appealed to the Court of Appeals. The court set aside Evans' conviction on the ground that the oral confession should not have been received against him, but affirmed petitioner's conviction in view of the trial judge's instruction. Well, the Supreme Court said because of the substantial risk that the jury, despite the instruction to the contrary, looked to the incriminating extrajudicial statements in determining petitioner's guilt, admission of the other co-defendant's confession in the joint trial violated Mr. Bruton's right of cross-examination secured by the Confrontation Clause of the United States Constitution, specifically the Sixth Amendment. That Confrontation Clause keeps coming up, doesn't it? Because it's a huge thing when it comes to court. And so you can't cross-examine what somebody else said when you allow in hearsay testimony saying that person confessed. You can't do that. So normally what happens when you have co-conspirator statements being admissible in court, you have to do a proffer. And it usually comes up in federal court because it really makes the federal prosecutors work. And at the hearing today, the prosecutor's like, Judge, we can't go through and look at every statement we want to use. That would just take up too much time. Wah! You're the prosecutor. You have all the resources. Go do the work. I do not understand why these prosecutors are hesitant to go to trial. It really makes me wonder if they think they don't have enough to convict. And so when you have a proffer of Bruton statements, the prosecutors have to say, here's the statement that I want to use. Here is why it is admissible. So what rule of evidence it's going to be admissible under, what exception, because it's a hearsay statement. And then you have to say what witness you're going to bring it in and under what theory. Is the statement made in furtherance of the conspiracy? Was it after the conspiracy? There's lots of different things. And so it is very important for the court to determine what statements are admissible pre-trial so that you don't have a mistrial. Bottom line. The other thing is inconsistent theories of defenses. That's another reason the court has to consider. Is there an inconsistent theory of defense that basically you're going to point fingers at each other? Well, that in and of itself, as the prosecutor said, isn't necessarily enough of a reason to do that, particularly when you have a third party that could be involved. Here we have Alex Cox, who is basically listed as an unindicted co-conspirator and more than likely committed these murders. So you can point the fingers at yourself as well as to a third party, which the defense will more than likely do as it relates to Alex Cox. So that's another reason why the prosecution says, don't worry about it. They're just going to point their finger at Alex Cox. They didn't mention his name, but they mentioned a third party. Now, here is something that I think is rather significant that came from the prosecutor today. When they were discussing Bruton issues, she says, Judge, we don't anticipate any statements. And I'm not really sure the district attorney truly understands Bruton statements. Yes, there are confessions, but are they statements in furtherance of the conspiracy, or when did they come? And she stated, the prosecutor stated, Judge, there are no Bruton issues that we are aware of. Basically, statements that can be used against one co-defendant and not the other, just like we had in the Bruton case, right? But she said that is evolving. She said that specifically at 31 minutes and 53 seconds into our playing of the hearing today. Now, what does that make me think? That maybe some of those statements that are being given by Lori Vallow while at the state hospital are coming in and could potentially be used against Chad Daybell and Lori Vallow, assuming Lori Vallow can actually come to court. So it's rather interesting, the turn of events. The judge sat on this motion for 5 months now. He needs to make a decision soon. I agree with Mr. Pryor. Chad Daybell has a right to a speedy trial. It's a lot different in the federal court system, where you basically, the speedy trial doesn't start until the last co-defendant comes in. Usually not the case when it comes to state court cases. And we can't wait to see if and when Lori Vallow is ever restored to competency. So what does that mean? Well, I think judicial economy falls in the favor of the prosecution. It makes sense to only have to do the case once. If there are no Bruton issues, well, that shouldn't be an issue. Antagonistic defenses, if Lori Vallow is not there, that's the issue. The real issue comes down to speedy trial. If the judge doesn't give Mr. Daybell a trial within a reasonable time under the Speedy Trial Act, which is usually 6 months in most state jurisdictions, the case could ultimately be dismissed based upon a violation of speedy trial. I think that's going to be the court's concern, and I think that Chad Daybell's trial is going to go in January of 2023, and we'll see if Lori Vallow makes it, but somehow I think, and she's not, the case is going to go forward. That's my gut instinct. We'll see if I got it right or if I crash and burn terribly. Only time will tell, but normally some of my predictions come true. Let's just wait and see.